Hi, my name is Kim Cullen, and I'm a personal injury attorney in Winter Park, Florida. We represent a fair number of clients who are insured by Medicare or who have insurance with a Medicare supplement or replacement carrier like Cigna, Aetna, or United Healthcare, some carrier like that under the Medicare plan. A lot of those people have questions about how Medicare affects their personal injury case. So I thought I would shoot a short video and talk about how being a Medicare recipient can affect even an automobile accident case or any other kind of personal injury case. So first of all, in an automobile accident situation, the automobile insurance, the PIP or personal injury protection coverage on the automobile will always be primary over Medicare. In other words, Medicare shouldn't pay any of a motor vehicle accident victims' medical expenses until all of the automobile insurance coverage is exhausted. After the automobile insurance coverage is exhausted, then the remainder of the injured person's bills will be treated just like any other injured person, someone that's injured in a car or in a slip and fall or any other kind of non-auto injury. Medicare can pay from $1, just depending. What that's typically going to depend upon is whether the person is receiving treatment from a doctor or facility that accepts Medicare. So if the injured person is originally treated in a hospital, let's say it's after a slip and fall accident, then the hospital is going to bill Medicare for the hospital visit and any of the charges that are associated with that. Once the person gets out of the hospital and starts seeing doctors, then it's going to be dependent on whether the doctors will accept Medicare. A lot of medical providers who see accident victims don't care to bill Medicare, and a lot of doctors who will take Medicare for payment don't want to treat accident victims for whatever reason. I've shot a video about that, and so you may want to look and find that video on YouTube or on our website to learn the reasons why that is. So if Medicare pays any accident-related medical expenses while the injured person is treating, then at the end of the injured person's case, when they make a recovery or attempt to make a recovery from the person who caused the accident, then Medicare is entitled to be reimbursed for what they've paid. And one of our jobs as the attorneys on a personal injury case is to reach out to Medicare, describe the injuries that happened to our client, and have Medicare send us a list of all of the bills that they paid that are related to the accident. Then if we make a recovery from the at-fault party, and only if we make a recovery from them, then we have to pay, or our client has to pay out of their settlement proceeds whatever the equivalent amount of whatever Medicare paid. So you have to reimburse Medicare for whatever it paid. Now, Medicare will give the injured person a discount. If the injured person has hired a lawyer to help collect the money, then the reimbursement is reduced by a pro rata share of attorney's fees and costs. So typically, the payback will be about 2/3 or 1/3, giving credit for 1/3 attorney's fees of what Medicare paid. So that's kind of complicated, but it's easy once you hear it a few times. So at any rate, if you're a Medicare recipient, you don't need to worry. Your treatment and bills should be paid seamlessly throughout a personal injury case, subject to a couple of wrinkles that are pretty easy to solve. But at the end of the case, just remember you're going to have to pay some money back to Medicare. And that's not a bad deal. Since Medicare never pays retail, they pay much less than retail. So the reimbursement to Medicare is often a better deal for our clients anyway. So if you have any questions about a Florida personal injury case or how Medicare affects a Florida personal injury case or how Medicare works in the scope of a Florida personal injury case, please call me or my law partner, Robert Hemphill, at 407-254-4901, or you can always text us at 407-644-4444.